Morning.
Good morning, Your Honors. May it please the court, my name is Allison Perry, and I represent the appellant Kenneth Smykowski in this appeal. I'd like to reserve 5 minutes for rebuttal.
Yes, ma'am.
This is a relocation case involving the party's 2 children who were 5 and 10 years old at the time of the relocation hearing. The former wife was allowed to relocate to Texas with the 2 children in April of 2023. The reason, importantly, the husband filed a motion to stay the proceeding with the trial court, and it was denied, and it was also denied by this court. So I just wanted the court to know that. The standard of review is de novo because the general magistrate and trial judge utilized the incorrect legal standard in reaching the conclusion that relocation was in the children's best interest.
Well, Ms. Perry, let me stop you right there, because I think even if there's not a jurisdictional problem, and I don't think we have a jurisdictional problem, I think there may still be a preservation problem. And if the arguments were not correctly preserved below, then obviously we wouldn't be on de novo review, we would be on fundamental error. So can you address for me why we would not be on fundamental error here?
Yes, because the original report and recommendation came out in October of 2022, and there was a very detailed motion to vacate timely filed, which said all the reasons, especially that it was perspective based in nature, that it should be stricken, it should be vacated. And so that motion to vacate was already done. On remand, the judge did not remove all the perspective based provisions of the report and recommendation, and so we have the same problem. The law does not require an exercise in futility for them to do another motion to vacate.
Well, I'm not, see, this is the thing, I'm not sure that this is futile, because when the issue was presented to the circuit court in the first instance, the circuit court sent it back, or rather, the trial judge sent it back for further proceedings. He agreed.
Correct.
And so I'm not sure it would have been futile for you to come forward and say, hey, I know you sent it back the first time, we've got the same problem in this order, which is not the same as the first order. It's not as though the general magistrate made the exact same recommendation and the trial judge just rubber stamped it. We have a new recommendation. We have new consideration. You could have said, you know, it's still not right. And there's nothing in the record to suggest that the trial judge would have said, you know, you're wrong, you're full of it, why are you wasting my time with this? So I'm not sure that this would have been futile.
Well, I just respectfully disagree with you, Your Honor. It was like a 35-page motion to vacate, which had several reasons why the report and recommendation should be vacated, but the main reason was because it was perspective-based in nature. The trial judge, the circuit court judge, is required to review the report and recommendation to make sure that it did comply with his remand instructions. And the trial judge evidently did not do that.
Well, you keep saying that it's perspective because the general magistrate took into account this is only a temporary move.
Correct.
But it's not perspective in the sense that the order is contingent on something potentially happening in the future, which is normally what a perspective.
But it is because the general magistrate stated that the specific reason it was granting this request was because of the nature of the request, which was a temporary one in nature.
So you're saying that the general magistrate, or you're just saying in family law cases, as a rule, the court cannot consider whether this is a temporary or permanent move in determining whether it's in the best interest of the child.
Exactly.
That's just off the table. It's not one of the factors that can be considered.
It cannot be considered because it's contingent. We don't know if it'll ever happen in the future, so you can't
But
base
what will happen in the future?
the future, her moving back to Florida.
Well, if in 3 years she doesn't move back to Florida, isn't that a basis to seek further relief?
That's what it says in the report and recommendation, but that's not really what the law is. The law is what is at the time of the hearing, which he would have to file a petition for relocation to relocate the children. It's at the time of the hearing, which would be 3 years from now if she doesn't move back, what is in the children's best interest? And by then, it may not be in their best interest to come back to Florida. We don't know. It's the future.
But that would be but that wouldn't depend on whether it's permanent or temporary. I mean, it could have been that's a whole different set of factors. What the trial court was doing was saying, as of this moment in time, does it make sense? Is it in the children's best interest to go to Texas?
And that's another argument I have, is there is no competent substantial evidence that it is in the children's best interest to relocate to Texas.
I understand that. I understand that's a separate argument that you've made, and I want to give you time to get to that. But I think I'm still having a hard time with understanding how this is prospective, because obviously the trial court still is looking at the factors as they stand now, but taking into account that this is a temporary move.
But we don't know if it's a temporary move because we don't know the future. We don't have a crystal ball like an author. It says the trial court does not have a crystal ball to look into the future to determine what's going to happen. And that's what this court did, is saying, I'm going to grant this because you're coming back. We don't know if she's going to come back. That's the future. That's future-based perspective analysis, and you cannot do that when you're determining the best interest of the children. You have to use present-based analysis and pretend that her relocation was permanent in nature. You can't say she's moving back. We don't know what the future holds.
Well, the statute itself talks about permanent or temporary relocation.
Well, could you expand on that? I mean, I know their temporary relocation is pending the outcome of the permanent relocation. They allow temporary relocations. But that's all that I'm aware of in the statute.
Yeah, the problem in this case is, as I understand it, is the move was anticipated to be for 2 or 3 years, but there was no definitive closed end. Is that right?
Yeah, there's no close end, and we don't know if they're gonna, they might love Texas and want to live there forever.
Yeah.
We don't know. Author in its prodigy says you cannot use perspective-based analysis when making a determination of what is in the children's best interest. And it is clear.
But the court is not saying in 3 years it'll be better for the children to be in Texas.
No, it's not saying that.
Did the court really say anything about how the relocation would benefit the children?
The only benefit to the children was they would live in an intact family, 2-parent household, which of course the former husband disputes because the intact family no longer exists because the father and mother are no longer together. So that's an intact family.
There's another child involved.
There's another child involved, however.
That's what they were referring to, an intact family.
But the family could also be intact in Florida because the wife testified in the supplemental record at 1340 in the record that if her relocation petition was denied, she would remain in Florida. And that, therefore, the children would remain together. And the best interest of the children to stay together would happen whether she lived in Florida or in Texas, because she wasn't going to move without the children.
But there was a discussion about the hardship that would be on her family to maintain 2 households, and the fact that one of the child that she had with her second husband would be in Texas, and
No, she
No?
said
keep all 3?
She said the child, on page 1340, the supplemental record, she stated that if her petition was denied, she would remain in Florida with the baby and the 2 children. The baby wasn't going to go anywhere without the mother.
So the second husband would be in Texas on his own. and she
On
would
his
take
own.
care of the kids.
Yes, and he would have to travel to see his children. He married into this family where this father has had 50% of the time sharing the children, has been extremely involved with the children, has always supported the children, has always had them on his health care, has always paid child support.
Well, except he said if he had known that they were on the new husband's health care, he wouldn't have had to pay for it.
Well, right, I mean, that's because, well, I mean, would you, it's, of course. But they're on his health care now, so, and they've remained on that without interruption. But the report and recommendation states the primary reason why the former wife's petition is being granted is due to the nature of what she seeks. The former wife has represented under oath to this court that her relocation to Texas will be until the deployment is over or until he retires. I mean, that is perspective based. And then it also says the former wife asked only for a temporary relocation, not a permanent indefinite one. That's at 897 of the record. Neither involved a situation where the requesting parent has represented that the move is only to be temporary, such as this one. It also stated the general magistrate's concern regarding the children having to attend a B-rated school from their A-rated school is mitigated by the fact the mother will be moving back to the area within 2.5 years. It's just replete with perspective-based analysis, which you cannot do under the Florida Supreme Court case of Author v. Author and its prodigy. In addition, there is no, in the alternative, I should say, there is no competent substantial evidence to show that this is currently, that it was currently in the children's best interest to relocate to Texas. Here they had access to both their parents, both the paternal grandparents, and they were very involved with friends, activities, you know, like I said, their family was nearby, and there's nothing in Texas for them except their stepfather. And a house, which, you know, no one told them to go buy a house in Texas, especially before the relocation petition was decided. Everything in this benefits the new spouse and the mother. It does not benefit the children. There's no educational opportunities in Texas for them. There were statistics in the brief that show how inferior their new school is. And it's just not in their best interest to relocate. They need to stay in Florida with their father, who is very involved, hands-on. This is akin to the Berevi v. Clark case, where the mother was allowed to relocate with her new husband to South Florida to take up a job opportunity and have better economic circumstances. And this court said, no, that's not enough. You have to show it's in the child's best interest. There are no more educational opportunities for the child in South Florida. And they reversed. An interstate relocation was reversed. And this court said you have to, you know, make it on the child's best interest, not the parent's best interest. Clearly, it's in the mother and her new husband's best interest for them to maintain one household. That's in their best interest. It's not in the children's best interest. Their best interest is served by remaining in Florida to interact with both their parents on a 50-50 basis. Other than that, I have no other argument except it's very perspective-based in nature. The issue was reserved because shouldn't have to do a motion to vacate after a motion to vacate. That's like doing a motion for rehearing and another motion for rehearing. There should only be required that you do one before you get appellate review, else this would be dragged out 3 years. And it would be, I believe it would be futile. So, thank you, Your Honor.
Thank you. You'll have 5 minutes when you come back.
Okay, thank you.
Good morning, Your Honors. May it please the court, my name is Sterling Lovelady, and I represent the appellee Alicia Monroe, formerly known as Alicia Simkowski. Your Honor, we're here because a mother was forced to file a petition for relocation to be with her husband and her young child from that marriage after her husband was relocated by the U.S. military from Florida to Texas, and a father who was seemingly uninvolved until that petition for relocation was filed, which is reflected in the general magistrate's ruling when he granted that petition for
So
relocation.
when you say uninvolved, what do you mean?
Yes, Your Honor, as reflected in the.
And is all this in our record?
Yes, Your Honor.
Okay.
As reflected in the general magistrate's ruling, there are a number of items which reflect that the former husband, the appellant, was not substantially involved with the children's activities or medical appointments until the supplemental petition was filed. For example,
You had a bunch of overnights with them.
I agree, I do not agree that it was 50-50, it was an 8-6 schedule, I believe, but what the general magistrate noted after a 3-day final hearing was that the husband had not taken the children to any medical appointments from the time of the final judgment in 2020 until after the supplemental petition was filed in 2022, and the former husband testified to that. Furthermore, the former husband testified at the relocation trial that he did not know the name of the child's dentist at the time of his deposition and the relocation.
That all might be a reason not to give custody to the former husband. But the former wife said that if the relocation's not granted, she would remain in Florida with the children. So it's not a matter of which one should be the custodial parent. It's whether the children should remain in Florida or be allowed to go to Texas. So I'm not quite sure how those factors weigh into that.
Your Honor, I believe it weighs into it because after 3 days of hearing all the parties testify and other witnesses, the judge determined, the general magistrate determined that the children would be best situated with the mother in Texas because the mother handled all of these items, rather than the mother who did testify that she would stay, as a mother's going to do what's best for her children. She testified that she would stay, but the general magistrate found that it would be best for the children to relocate immediately to Texas, where the mother would continue that continuity of care as she had taken all the medical appointments and those sort of things.
But there were local grandparents in Florida that also contributed to these children's lives, wasn't there?
There were local grandparents, although how local was in dispute, and actually the general magistrate in the recommended order, the amended recommended order, found that the father of the appellant was not available on nights and weekends because he was working, and the mother, the paternal grandmother, was 2 hours away. And the father did testify at the relocation hearing that he would be relying on those two for childcare and not his girlfriend at the time. So the availability of childcare was in dispute, and the general magistrate weighed that in his recommended order. But we're asking this court to affirm the lower court's decision for 2 reasons. The first one being the jurisdictional issue, which was been discussed already, because the appellant failed to preserve this issue for appeal. Now, we disagree that it would be futile. And in fact, under the current version of the Florida Family Law Rule of Procedure 12.490, anyone seeking relief from an order from a general magistrate, a recommended order, must file a motion to vacate. Now, when comparing this rule to the prior version, which was amended in May 2022, the prior version required the filing of exceptions. Now, it's very important to note that both of these rules use the word may, that you may file a motion or file exceptions to seek relief. However, this court's prior ruling in Judy v. Judy made it clear that if you fail to file exceptions to a general magistrate report, it's not preserved for appeal. But alternatively, we're asking this court, even if it has jurisdiction, to affirm because the general magistrate.
You're mixing terms. You're talking about preservation and jurisdiction as sort of the same thing. Are you
Well,
arguing that we have no jurisdiction, or are you arguing that the issues raised are not preserved?
Well, both, Your Honor. The cases, there's a line of cases that have been published after the rules were amended in 2022 that state that if you fail to file the motion, the issue is not preserved, therefore there is no appellate jurisdiction to consider the issues. And one of those cases is Gatchel v. Kravoshia, the 5th DCA, September 2023, where the 5th DCA held that it was critical in order to invoke appellate jurisdiction.
Well, we have a final order of the trial court and a timely filed notice of appeal. And that's why I'm getting hung up on the assertion that there's no jurisdiction.
Well, because there's been other appellate courts and this court's decision under the prior version of the rules that if you fail to file prior exceptions or a motion to vacate, that there is no jurisdiction because it wasn't preserved for appeal. So,
Is there any other circumstance where the failure to preserve an argument is jurisdictional? In the civil or if you know, criminal context? Because to my knowledge, there isn't a situation where it's jurisdictional, it's just an issue of preservation.
I'm unsure, Your Honor. However, I know in this situation, The appellant cites to 2 criminal cases saying it would be futile, but those criminal cases relate to sentencing and making objections on the record during the sentencing. But I would suggest that it is clear that you have to take steps in order to invoke this court's jurisdiction over these issues. Even the appellant cites in his initial brief the requirements for the trial judge to review the general magistrate's order. The trial judge has to look at the finding of fact, the application of the law to the facts, and ultimately decide if it was a proper decision based on the law and the facts. And the trial judge in this case simply did not have the opportunity to do that. The order that's before you is an amended order. And as Judge Rothstein-Yoakum mentioned, this is a different order. This is not the same order. This order was amended to strike future speculative decisions based on a future relocation. We don't have a future relocation in this case. We have an immediate relocation. The judge in this case found, the general magistrate found, that it was in the best interest of these children to relocate immediately. And so under the line of cases, and again, going back to this court's decision in Judy v. Judy, this court also cited to a decision in Lascobar v. Lascobar, which was a 3rd DCA case from 2015. And in Lascobar, there were 2 orders. So it's a good demonstration of what happens when there are 2 orders, and only one of them exceptions was filed to. So in Lascobar, there was a 2010 case and a 2010 order and a 2012 order, both related to interest on child support. Now, in the 2012 order, there were exceptions filed, and then it was appealed, and all the issues were raised in the appellate briefs. However, on appeal, the 3rd DCA held that because there was no exceptions filed to the 2010 order, the court could not consider the issues that happened in 2010 and prior, because those were not preserved for appeal. But even if this court finds that it has jurisdiction to consider these issues, we would suggest that the general magistrate was well within his discretion to grant the relocation because there was competent and substantial evidence. Now, the standard in reviewing the general magistrate's recommended order should be an abuse of discretion, as is seen in the Supreme Court's decision of Canacris.
Let me ask you, there seems to be sort of an inherent tension between 6113-001 and 6113. Because 6113-001, which deals with relocation, the factors that it sets forth for a trial court to consider necessarily focus on the parent and the parent's interests. Yet there is also the requirement that the trial court consider any other factor affecting the best interest of the child or set forth at 6113. So there's no question that the trial court in this case, I think, went through, or the general magistrate went through a very detailed examination of the 6113-001 factors. But how exactly does 6113 fit into this?
So I would say it fits together because the court, in making its ruling, has to consider the best interest of the children. And in doing that, it's not improper for the court to consider the best interest, what may be best for the parents in those situations. And there's been case law to suggest that. The court doesn't have to completely ignore what's best for the parents, although it can't base its decision purely on that. In this case, the general magistrate did not do that. And we can see that through a litany of items where the general magistrate cited back to facts in the record and supported his decision based on the evidence presented at trial. I would disagree that there was only one fact that suggested it would be better for the children. In fact, there was a number. The first, which has already been said, which was that the mother has continuity of care and continuing care for the children as far as their medical appointments. Again,
wouldn't she have more continuity of care if she kept them in Florida with the doctors and everyone that they'd been seeing all along?
I disagree with that, Your Honor, because, and the general magistrate disagreed with that, because the mother was living in temporary housing at that point. And as mentioned, she didn't relocate until after the amended order was issued. So the mother did, in this case, stayed in Florida. But the general magistrate found that it was best for these children for her to move to Texas, live in one household with her husband, who, it's mentioned later on, that she would be able to have available for childcare. And as a parent, Judge, taking 3 children to the doctor, not the best situation. So potentially that's something the general magistrate was considering when he found that it was in the best interest of these children to move to Texas, to be in that family household, as previously mentioned, with her current husband in a unified household. There were other reasons, including the general magistrate found that it is best for these children to live in a household with their younger brother, their stepbrother, and their stepfather, and to not be away from them. And this was not a decision for the other child. This was a decision that it was best for these children to live in that household with a family unit in Texas. Now, there are other reasons, including one where it's very important, which hasn't been mentioned, that the general magistrate found that the mother would be better suited to guide these children into their teenage years. There was a discussion of they were coming into their teenage years and what would be best for them. And the general magistrate found again that relocation and that being with the mother in Texas would put them in the best position. Now, there's been some discussion about schools, and I would disagree that there was an issue with the schools because the general magistrate in his amended order found that the children will be able to continue attending schools of similar quality in Texas as they would in Florida. And important that the children did not change schools and move to Texas until the end of that semester, so that was considered, the children were not uprooted. The general magistrate also found that the former husband would be able to maintain his relationships with the minor children through frequent in-person contact. Now, the appellant testified at the relocation hearing that there were direct flights from Tampa to Houston. He also testified that the children in this case could handle a 2-hour direct flight from Tampa to Houston and Houston to Tampa. The general magistrate also found that the father appeared to be financially motivated in his objection, that he didn't want to pay for the cost of transportation. The general magistrate, again, in the best position to consider the credibility of the witnesses and the evidence in this case, gave the mother credit in the order for being very genuine in remorse and saying she did not want to be in this situation. She didn't want to be forced to put her family in this position, but with her husband being involuntarily relocated, she had to do what was best for the children, and the general magistrate found that her petition for relocation was in good faith. Although the mother did say that she would stay in Florida, after 3 days of testimony and evidence, the general magistrate found that that was not in their best interest and that it would be in their best interest to relocate. And lastly, the general magistrate found in the recommended order that the father works remotely 90% of the time and would have the ability to travel and work remotely, so it wouldn't interrupt his work schedule. Appellant also testified at trial, in the relocation trial, that his territory for work, working 90% remote, he travels frequently, and his territory ranged from Chicago to Louisiana. So as part of this relocation, the judge also considered the father's position and would he be able to visit and maintain that relationship. Therefore, if this court finds that it has jurisdiction over these issues and they've been properly preserved for appeal, we would respectfully ask this court to affirm the trial court's decision. Thank you, Your Honor.
Thank you very much. Ms. Perry, you have 5 minutes.
Thank you, Your Honor. First, I take issue with the fact that opposing counsel claimed that this father was not involved with these children. I'm going to read from the former wife testified that the children had a relationship with the former husband's parents and step-parents who lived in Florida, and they frequently visited them. She testified that the former husband always exercised his time sharing since the divorce. The former wife testified that the former husband attended all the important events in their daughter's schools, including teacher conferences. She testified that her current husband was involved in taking care of it. This father was very involved with his children. They were sharing 50-50 time sharing after the divorce, which ended when there was an unsuccessful mediation on the petition for relocation. This father did testify that he didn't take the children to their medical appointments because the mother made it difficult and it was, something she wanted to do. So the fact that, that's not, it would be in their best interest to stay in Florida with their medical providers, as was pointed out. And there's just no competent, substantial evidence to support this relocation. The fact that the mother would stay in Florida with the baby and then the father could see the children on a 50-50 basis or a 6-8 basis is just in their best interest. There's nothing to support the relocation petition, and I ask that this court reverse it.
Thank you both very much. These kind of cases are always very difficult. appreciate you all's efforts in trying to show us the way.
Thank you.
Have a good day.
You too.
We are adjourned to deliberate these cases.
All rise.